Law Watch, Coleman Jackson, attorney and counselor at law. Welcome to Law Watch. My name is Coleman Jackson, and I am an attorney at Coleman Jackson PC, a taxation, litigation, and immigration law firm based in Dallas, Texas. On our topic for today is last wills and testaments and Texas estate law during this coronavirus pandemic. Other members of Coleman Jackson PC are Yulissa Molina, tax legal assistant, Reina Munoz, immigration legal assistant, and Myra Torres, public relations associate. On this Law Watch video, our immigration legal assistant, Reina Munoz, will be asking the questions, and I will be responding to her questions on this important estate and inheritance topic, last wills and testaments and Texas estate law during this coronavirus pandemic.
Good morning, everybody. I'm the immigration legal assistant here at Coleman Jackson PC, a tax litigation and immigration law firm right here in Dallas, Texas. Today, I'm going to be talking with the attorney about last wills and testaments and estate law in Texas during this dreadful pandemic. Attorney, today we're going to be discussing a topic that many folks just don't want to talk about. You know, folks getting sick and spending weeks and even months in the hospital from this dreadful COVID-19. I mean, attorney, many people have been in hospitals for weeks and even months fighting just to breathe and live, and so many people have died due to this dreadful pandemic. My first question is this: how can people in Texas who are sick in the hospital for weeks and even months lawfully let loved ones or somebody else take care of their financial affairs and children while they're in the hospital fighting for their lives?
Good morning, Reina. There has been a lot of pain and death since the beginning of this pandemic. And yes, sickness and dying are things we tend to want to avoid talking about or dwelling on. But this pandemic has shown us that both of these are integral parts of life. And yes, there are some things that people can do to lawfully and smoothly authorize others to take care of their financial affairs and children in an unfortunate event that they get sick from this dreadful virus and have to spend weeks or even months in the hospital. First, let me talk about financial matters such as banking, insurance, and regular money matters without court involvement in the process. And then I will discuss how folks can authorize others to take care of their minor children with court involvement in the process. In both instances, whenever you have court involvement, you will most likely have delays and more costs, two things you want to avoid. Durable power of attorney. Texas first allowed people in the state to appoint others to manage their property and right to property in 1972. That is when the durable power of attorney provisions were enacted in the Texas Probate Code. Durable power of attorney generally grants another person broad, sweeping powers to practically do anything and everything in terms of property rights and rights to property as a person can do themselves. Durable powers of attorneys can be dangerous for this very reason. Powers under a durable power can be limited and even postponed by inserting a triggering event, such as a declaration from a physician that the principal is incapacitated and unable to handle their financial affairs. Durable power of attorney does not require court involvement, but the more limitations inserted into them could diminish their effectiveness. Keep in mind that the whole idea is to give the agent a document authorizing them to handle the principal's affairs, financial affairs, while the principal is incapacitated. To do that, third parties must feel comfortable dealing with the agent in the principal's absence. The more complicated you make the durable power of attorney, the less likely they will honor the power. Durable power of attorney instruments must be well written and signed in front of a notary public before the principal becomes incapacitated. Again, they must be executed before the principal becomes incapacitated, and they should be placed in the hands of competent and trusted individuals, agents, or advisors. Family members or trusted persons must know the DPA exists. Finally, durable power of attorney instruments must clearly designate another person as an attorney in fact or agent, and they must indicate when the powers granted to the agent will become effective. Let me just add, only adults can lawfully execute a durable power of attorney in the Texas Probate Code. A minor in Texas is defined in the Probate Code as someone who is under 18 years of age. So in summary, the durable power of attorney can be used by adults in Texas to smoothly and lawfully give property management authority over their property to another adult without the involvement of the courts. Law is complicated, however, so there are certain complexities dealing with durable powers of attorneys that I have not covered here in this podcast and in this Law Watch. And state law is specific. This matter is specific, as I'm discussing it, to the state of Texas. So folks with DPA concerns should seek appropriate legal advice in their geographical regions regarding their particular situations.
Well, okay, then that deals with managing property and money and stuff like that. What about their minor children? How can parents lawfully give a trusted friend or relative or somebody custody of their minor children while they're fighting for their lives in the hospital, or they're even incapacitated with this dreadful disease at home? I mean, like the kids' health, food, clothing, shelter, and educational needs. Things like that while their parents are fighting COVID-19, you know?
Raina, that is a very good question because folks need to know how to place things in order for the protection and managing of their minor children in the event they unfortunately become sick and incapacitated from complications due to coronavirus. The Texas Probate Code permits a person who is not incapacitated to execute a declaration of guardian to designate certain persons to serve as guardian of the person or guardian of the estate. Typically, the same individuals appointed as dual power of attorney are also designated as guardian of the estate. This could be helpful to avoid confusion and conflict, because obviously conflict could develop if you appoint two different people or persons or entities to serve as dual power of attorney and dual power and guardian of the estate. A different person could, however, serve as guardian of the person. I will end by saying that unlike dual power of attorney, guardianships require court involvement. Let me repeat, guardianships require court involvement in Texas, but it's more likely that a court will allow persons designated to serve as guardians if a person has designated that person to serve before becoming incapacitated. The court could, in that event, appoint, if a person becomes incapacitated and has not designated an individual to serve as guardian of their person or their minor children, the court could appoint a guardian that is perceived to be in the best interest of the person or the minor children.
My second question is this. How can people in Texas smoothly and lawfully leave their things to the people they love if they die from this dreadful virus?
That is a good question. And in Texas, the answer to your question, Raina, depends upon the type of property being transferred. A last will and testament is a written instrument used in Texas by a testator, that's the person who's died, to transfer probate estate to his heirs or whoever they want. A person can give their property to whoever they want. Usually property such as real estate, automobiles, brokerage accounts, and other financial accounts like these. Tangible personal property, royalties, and money on hand or money owed or things owed to the testator all pass under the last will and testament. Not all property of the testator is probate property, however.
So not all property of the testator is transferred under the last will and testament. Is that what you're saying? Attorney, what kinds of property do not pass under the will?
Raina, that is exactly what I am saying. Several classes or categories of property is not passed under the last will and testament. Property that do not pass under the last will and testament of the testator are like these. Number one, Texas is a community property state. Keep that in mind. As a community property state, the testator's spouse 1/2 interest in the community property does not pass under the testator's will. Number two, life insurance passes directly to the beneficiaries designated in the policy. Number three, property held by a revocable or irrevocable trust does not pass under the will unless the estate is the named beneficiary in the trust. Property under a trust passes under the terms and conditions set forth in the trust. Number four, individual retirement accounts does not pass under the will unless the estate is the beneficiary in the account. This is just intended to be some of the types of property that does not pass under the last will and testament. It is not an exhaustive list.
Okay, attorney, my third question is this. Does the heir of the testator have to pay any taxes on the property received under the will or otherwise? But first, I'm curious, who can make a last will and testament in Texas anyway?
Let me take your last question first, Raina, as to who can execute a last will and testament in the state of Texas. The testator, that's the person who's died, must be at least 18 years of age, or married, or divorced, or widowed, or a member of the armed forces of the United States. Now, as for federal taxation of inheritances, let me just say for now that life insurance benefits received are excluded from federal taxation. Other aspects of taxation I will for now leave for a future blog because it gets complicated and perhaps too much to discuss in a Law Watch video. Anyone interested to hear or see more on the taxation of inheritance should follow our blogs at www.cjacksonlaw.com.
Well, okay, attorney. Further explanation and details regarding inheritance, taxes, and other tax details can be left for your detailed blogs. Thanks for giving a good overview of how folks incapacitated with this dreadful pandemic can authorize trusted loved ones to manage their property and take care of their minor children during this coronavirus nightmare. People can follow our Legal Thoughts podcast and read our tax litigation immigration law firms blogs on other topics like this if they're interested at www.cjacksonlaw.com, and they can select our English, Spanish, or Portuguese website, whichever suits them best.
This is the end of Law Watch for now. Thanks for giving us the opportunity to inform you about last wills and testaments and Texas estate law during this coronavirus pandemic. If you want to see or hear more taxation, litigation, and immigration legal thoughts, podcasts, or Law Watch videos from Coleman Jackson PC, subscribe to our Legal Thoughts podcast on Apple Podcasts, Google Podcasts, Spotify, or wherever you listen to your podcasts. Or subscribe and watch our Law Watch videos right here on our YouTube channel. Stay tuned. We are here in Dallas, Texas, and want to inform, educate, and encourage our communities on topics dealing with taxation, litigation, and immigration. Until next time, take care. Law Watch has been a presentation of the tax, litigation, immigration law firm of Coleman Jackson, PC, 6060 North Central Expressway, Suite 620, Dallas, Texas, 75206. 214-599-0431, Spanish 214-599-0432. Website www.cjacksonlaw.com.
Viendo Leyes ha sido una presentación por la firma de abogados Coleman Jackson PC, impuestos, litigación, inmigración, basada en Dallas, Texas. Estamos localizados en el 6060 North Central Expressway, Suite 620, Dallas, Texas 75206. Nuestro número en inglés es 214-599-0431. Nuestro número en español es 214-599-0432. Y nuestra página web es www.cjacksonlaw.com.